Today's episode is brought to you by Leeward Elite. Leeward Elite is the solution to your technology and computer needs. Don't you deserve a better technology experience, a worry-free experience, a cost-effective experience? Leeward Elite members enjoy peace of mind, greater business productivity, and unlimited support. That's right, unlimited support. Contact a Leeward Elite concierge at leewardelite.com. That's leewardelite.com. And folks, I've gotten to know the Leeward Group, and not only do they provide outstanding IT solutions, they're also a very socially conscious group. They give back to their community in so many ways. I highly recommend contacting Leeward for any of your IT or consulting needs. I thank them for sponsoring and hope you enjoy today's episode.
Looking to buy, sell, or grow your business to position it for a sale? As the owner and managing partner of Sun Acquisitions, Domenic Rinaldi has personally been involved in over 300 M&A transactions. He has seen and done it all, consulting with large and small businesses across a broad range of industries. On M&A Unplugged, he'll interview buyers, sellers, and their advisors about their experiences scaling, selling, and acquiring businesses. On every episode, you will get key learnings, but most importantly, you will be better prepared for your own acquisition or sale. This is M&A Unplugged with your host, Domenic Rinaldi.
Law professors constantly ask students to be prepared to argue either side of the law when discussing a legal issue. That way, you can learn the law from all angles, seeing into every corner of an argument. On today's episode, we're going to try something new. We're being joined by two expert attorneys, Schreiner and Jeff Petersen, who will be discussing several legal issues that arise in most M&A transactions. One of them will be taking the seller's perspective, while the other will be providing the buyer's perspective. I think the M&A Unplugged community could really benefit from seeing several important issues from both sides of the table, so you're better prepared for your own M&A transaction. John is with Perkins Coie and focuses his practice on providing counsel to closely held established and emerging companies for their daily business needs. He also represents private and public companies in mergers and acquisitions, divestitures, private equity financings, corporate governance, commercial contracting, and general business matters. Jeff focuses his private practice on transactional matters including corporate formation, venture capital, and private placement transactions, mergers and acquisitions, and general corporate advisement. Jeff serves clients across the country and maintains offices in California and Illinois. John and Jeff, welcome to the M&A Unplugged podcast.
Thank you. It's good to be here.
Thank you, Dominic.
Yeah, so as I mentioned, this is the first time I've done something like this, so we'll be feeling our way through it. But before we get into it, if you could provide just a little bit more about your backgrounds so the M&A Unplugged community gets to know you a little better. Jeff, why don't you start us off?
Certainly. Thank you. I've been a corporate attorney for going on 20 years now and was a partner with K&L Gates in Chicago. And actually, John and I were colleagues there. And about 8 years ago, I decided to open up my own practice and have since that time represented mid-sized and small companies in a host of merger and acquisition transactions, as well as private placements of securities.
Awesome. John, how about yourself?
Sure. After leaving K&L Gates, parting ways with Jeff, I joined Perkins Coie, international law firm with a real strong presence up and down the coast and here in Chicago. With my practice, I really like getting to know my clients and understand my clients' business needs so that when I'm offering advice, in addition to giving them the legal resources or legal answer that they're looking for, I can also give them a practical one or business answer, help them evaluate and mitigate risk and not get in the way of the business needs of the company or the client.
Awesome. So guys, I'm really excited about this. I think, Jeff, you had brought this concept to me of, how about if we did a point counterpoint when we talked about you participating in this podcast. And I thought, it took me back for a second. And then I really started to think about it. I thought, well, that's a great idea because so often as intermediaries, we're in a situation where either we represent the seller or the buyer, and there's a sticky issue that comes up. And as you guys know, doing M&A transactions, there's many sticky issues. And I always find that my team and I are having to educate our clients so they understand the other side. Like, so, because many of these cases, it's, what's good for you is bad for the other party. And so I think it's really so important for us to have that dialogue. And great that you guys, one, have history and have been colleagues for a long time, but can take, either side of an issue. So I'm excited to dive into this today.
Yeah, that sounds great. I can't wait. I guess I was going back to the old days of Saturday Night Live with Dan Aykroyd and Jane Curtin and their point counterpoint, but we'll leave the late night language out of it.
I love that. We're going to a signature line out of this. We're a clean labeled show, but that was a great skit. So, I think we had talked about, maybe diving into a few issues, and why don't we start with indemnity? And why don't we start with, what's the definition of indemnity? Why is it important? And then we can, go into the seller perspective and the buyer perspective.
Sure. Sounds great. So, in a typical purchase agreement to purchase the assets or stock of a company, you're going to have representations and warranties that are made about the company. And the seller's going to tell me that they own the company, that they don't have any issues with their employees or their customers. There's no litigation. They'll show me their financial statements, let me know that those are true and accurate, prepared in accordance with GAAP, a variety of other reps and warranties. If any of those are wrong, either intentionally or unintentionally, the buyer would have a post-closing claim for breach of contract. And typically will include an indemnification scheme within the purchase agreement. The indemnity scheme lays out the limitations on what a buyer is able to recover. The indemnification scheme also has the mechanics for how a buyer would make a claim for both direct damages and third-party claims that come against the buyer. And finally, the indemnification scheme will identify the scope of damages that are recoverable. So this is really a negotiated, what is the exposure of a seller after closing, and how is a buyer able to be made as close to whole as possible if the company they're buying isn't the company they thought they were buying.
Yeah. So the premise, John, being that the seller has to warrant that, they're passing along, accurate and materially accurate information to the buyer. And if not, the buyer's got the right to go back after them. So
absolutely.
Jeff, why don't we start then on your side? I think you're going to represent the seller's perspective, right? So
that's right.
From a seller's perspective, what's important? What's your counsel that you're providing here? And look, and I know there are so many nuances to reps and warranties and indemnities, but at a high level, where are you advising a sell side client?
Sure, and this is the area that always gets a seller's attention, because what I tell them is these are the provisions or parts of the contract where you might have to give your money back, or at least a portion of it. So that always captures the attention. And what I tell them is, on the reps and warranties, they're generally standard, but you need to go through them closely. We need to make sure that they're not overreaching on the part of the buyer. And then what we try to do is we try to put in limitations in the indemnity. For instance, things like a cap, right? So a lot of times what you'll say is the buyer can get indemnified, but only up to a certain amount of the purchase price, say 10% of the purchase price. And there are certain exceptions to that we can get into. If it's an outright fraud, if it's something fundamental, like you actually don't own assets which you say that you're selling to the buyer, those are exceptions to the cap. But in general, you can get a cap of, say, 10 to 20% on the purchase price. And you can also get a limitation period, which is for, say, a 1 year or 2 year period after the sale. Then the buyer can come back to you if there's an indemnified claim. But if it goes beyond that period, what you generally say is you've owned the company. It's past a point where you should be able to come back to the buyer and say, fork some money back over. Again, there's exceptions there for things like fraud or some fundamental representations as well.
And so, Jeff, let me ask, in a situation where you represent the sell side client and you've done the initial draft of the asset purchase agreement or stock purchase agreement, where are you typically starting? Where are your starting points on caps and time limits and I guess we won't get too detailed in the baskets and things like that, but at the highest level, where's your starting point typically?
Sure. With the very lawyerly caveat that every situation is different. In general, I would start at a 10% cap with a 1-year survival period. And I'll always, even if I'm drafting the agreement, I want to be fair and balanced because I think it doesn't help anybody to be too extreme because it just adds time and expense to both sides. So I will put in exceptions there for things like fraud. If it's a fraud, there should be no cap. If you actually didn't own the assets, there should be no cap. And I think what John will say as the buy side attorney is he'll want to see things in there in the fundamental representation that's uncapped, things like taxes and maybe employee benefits and intellectual property claims.
So you brought up a new term, fundamental. But let me kick it over to John a little bit to get his reactions to your starting point around 10% in 1 year. And John, generally, how are you advising buyers through that process?
I take a very similar approach in that I want to focus on the most important issues for my clients so that we can get to a deal sooner than later. Time can kill deals. A lot of times you may have a rollover or post-closing employment, and you need to maintain a good relationship with the seller. Depending on the counsel on the other side, I would typically try to start with a 15 to 20% cap on what I call operational representations and warranties. So talking about no litigation, no issues with employees or customers, and then go to a enterprise value cap for more fundamental. You own the company, you've paid your taxes. And depending on the industry that the company is in, if intellectual property is particularly important, if there's a heightened risk of environmental issues, I'll tend to have an extended rep where I'll have a higher than the 15, 20%, but not quite as high as the entire purchase price. That said, I have one client that's been doing a number of acquisitions across the United States. Their target companies tend to be represented by less sophisticated counsel. Oftentimes they'll be using the lawyer that they've used for the last 10 years to help them with sort of everything, but has never done an M&A deal. And in that case, I'm actually starting without any limitations on my indemnification. And believe it or not, probably 7 times out of 10, we get away with that. To Jeff's point earlier, though, while that's a pretty aggressive move, it leaves my client with all the leverage if there's an issue after closing. But we still do quite a bit of due diligence, and we work closely with those sellers to make sure that we do ferret out ahead of time any potential issues, because we do not want to come into a situation, buy a company, and figure out that there's something wrong with it and now have to deal with litigation or the threat of litigation to get made whole. We'd much rather identify that issue ahead of time and either elect not to do the deal, adjust the purchase price, or otherwise correct the issue.
Yeah. It's interesting. You brought up a situation where you had an inexperienced attorney on the other side and you were able to push the limits and the cap. Sometimes we experience just the opposite. If there's somebody that really doesn't do a lot of M&A transactions or none at all, they're actually an impediment to the process because they just don't have enough knowledge, and they dig their heels in on issues that they shouldn't be digging their heels in, and effectively can kill a deal or cause the other party to have to bend in ways they shouldn't have bent because you just didn't have an experienced advisor on the other side.
You're absolutely right. I had a deal a couple of years ago. We were buying a forklift company, and the family lawyer who was the trust and estates lawyer dug his heels in. We had a series of company representations and warranties, and the indemnifications were made by the selling stockholders. We were doing a stock deal. And he didn't think that the stockholders should have to indemnify for a breach of the company reps. And he just couldn't quite understand that after closing, we own the company. And if the company was indemnifying for a breach of its reps, we'd be paying ourselves with our own money. And it took quite a while. I think I ultimately relied on a ABA model stock purchase agreement with commentary to educate him. But generally, I'd rather have a good lawyer on the other side. The agreement's going to wind up much more middle of the road. But I think if in diligence and negotiations, the parties are doing things right, you're going to have a good deal, and you're hopefully not going to have an indemnification claim afterwards. And getting that deal done is more important. So if it were up to me, I'd have Jeff on the other side of the deal rather than, someone who doesn't do this for a living.
Yeah, I think it's such a good point to the M&A Unplugged community. Having an experienced attorney that it has really done a number of M&A transactions and different types of transactions is so important. At the end of the day, it will save you money. Believe me, because I've seen the other side of it, and I'm sure Jeff and John have as well. John, you bring up diligence, which I think is an important component of indemnity and reps and warranties. What role does the quality of the diligence information play in your starting point on indemnities in a negotiation?
That's a great question. If we're both conducting full due diligence, and some clients, opt not to do as deep of a dive in due diligence. They're looking to quickly get a deal done. They're looking to save on expenses. But assuming that we've done a deep dive and assuming that we're seeing what we want to see, we're seeing good corporate records. There's standard terms and conditions in their contracts that are reasonable. It gives us a lot more comfort that there's not something that's been overlooked. Most of the time when you have a post-closing claim, it's not because somebody was hiding the ball. It's just because they didn't realize it, or they didn't know what they were doing wrong. So if we're seeing a company that is in good shape, we're generally going to be more reasonable on our indemnification because we don't have as big of concerns. Similarly, if the company has reputable counsel, we get a little bit more comfortable. So the brand of your counsel is important because we know that you've been getting good advice. So a lot of times when I have a client that's getting ready to sell, before the sale process even kicks off, we'll start doing diligence ourselves on that client to make sure that if there are any obvious issues that we can correct those ahead of time before prospective buyers come in and have a look. Just really get your house in order in advance of a sale process. I imagine you help out with that quite a bit too, Domenic. We work with advisors pre-sale to do that quite often.
Yeah, we try to get our clients to pull together diligence early and often. And as a matter of fact, as soon as we engage, we start to build out a data room, and we continue to do that throughout the process. Encourage the client to do that. Hey, Jeff, I'm interested. I'm sure you've been in a situation where you've got a buyer counsel who's trying to push the limits on caps and time limits because they were uncomfortable with diligence. Yet, your position might be, look, we were open kimono. We gave you the opportunity to come in and look at everything. What's your pushback when you've got a buyer counsel that's trying to push the limits because they're hiding behind diligence?
Yeah, that's a great question. So one thing is there's a lot of market data out there as to what's market, what are standard terms. So we use those, and we rely on our work too. It's especially helpful, Domenic, when we have an advisor like you on the seller side, because that's a party who can almost serve as sort of a mediator sometimes and talk through the attorneys to the business people as to what really is market standard. I was just sharing with John the other day that I had a deal, and again, buyer's counsel, big firm, but they were just adamant that indemnity wasn't going to be the sole and exclusive remedy. And that's an important point for, business owners to know is you want the indemnity, again, except in cases of fraud generally, that's going to be your sole remedy. So if there's a problem post-deal, everybody's going to look to the indemnity provisions as to how does this play out and what are our limitations? Well, buyer's counsel just wouldn't accept that and said, no, we're not going to have sole and exclusive remedy. And we just wound up loading up with data, giving about 6 or 7 different studies showing that that's in about 99% of the deals that's going to be your sole remedy. And that finally got them to give on that point.
Yeah, that's great. That's a great example. Have either of you or both of you been exposed to rep and warranty insurance, and interested to get your opinion on that? I interviewed Matt Soma of ABD not too long ago, and they're a rep and warranty insurance broker. And it seems like that kind of insurance has really been popping up more and more. And It allows the seller to walk away with 100%, and it gives the buyer, a lot of comfort. Obviously, not around fraud and things like that. But where do you think that plays a role? Do you like to see that? Do you not like to see rep and warranty insurance? Interested to get your opinion.
I'll leave this one off, Jeff. As a buyer, I oftentimes will start a bid with the concept that we will include rep and warranty insurance. I think it's becoming very prevalent in certain spaces, such that if as a buyer you don't offer rep and warranty insurance, you're actually at a disadvantage. So the PE funds tend to be doing this in their middle market, upper middle market deals. The strategics are a little slower to catch on. I'm certainly advising my clients to do that and saying you're at a competitive disadvantage if you're bidding against a private equity fund and they're coming with rep and warranty insurance, telling the seller, absent a few things, you've got a very specific and very low post-closing potential liability, and you're going to be able to walk away with that money and actually buy that boat or get that second house and go to the beach and not have to worry about it. So I think it's becoming more and more prevalent. It's certainly a lot more affordable than it was when it originally rolled out. And I'm starting to see it even in lower middle market deals where it can make economic sense to bring that to the table.
Yeah, I understand the premiums have really come down. I don't know what's going to happen here post-COVID environment, right? Because there's a brave new world, but pre-COVID, it seemed like the premiums were coming down and making it much more affordable for a lower middle market transaction to actually consider rep and warranty insurance. Jeff, what's your perspective on this?
I echo what John says. As on the seller side, you love to see that the buyer's going to have it in place, and I've had buyers get that insurance when the seller hasn't. So if it's something that's within the buyer budget and we think there's any potential for an issue, it helps everybody sleep better at night.
Yeah. So, Jeff, in situations where you know what market is, you've got a reasonable attorney on the other side, but you've got a client that's being completely unreasonable.
Never happens.
Yeah, never happens, right?
I'll trade you clients, Jeff.
Yeah. And maybe, I find oftentimes there's a motivation factor that's at play here when people dig their heels in on things that they shouldn't be digging their heels in, and they're not taking the wise counsel of their attorneys who've done lots of these transactions. What's your approach with your clients when they're digging their heels in and they just shouldn't be?
So in a situation like that, that's where I think some tough love is called for. I have been in that position before. And what I tell my client is I would never come in and try to run your business because you'd be out of business within a week. But here, based on my experience having done these deals hundreds of times, you're on the wrong side of this one. It's counterproductive. And even as your advocate and someone who's fighting for you, I'm here to say that this is one that's just unreasonable. And it's not something that the buyer should be expected to give on. And sometimes it takes some time to break down those walls. But in general, good business owners, they've been through the wars before, and you can get them to understand after some time.
Yeah, John, how about you? What do you have a magical thing that you use with your clients that helps move the needle?
If I'm on the buy side, I'll often put on my law professor hat and use the Socratic method and ask them questions to get to the right answer. So if they're intransigent on a certain rep or limit, I'll have them walk through with me and I'll say, well, what are the likely scenarios and what are the unlikely scenarios where we're going to see a breach here? And, what keeps you up at night? What are you worried about here? And as they walk through that and articulate their concerns, oftentimes we feel that we can solve for that either by narrowing the rep to a specific concern or helping the client to land at the conclusion that, this company really isn't ever going to have this issue. And we're willing to trade and take the risk here, which we've identified to be minimal, in exchange for lessening our risk somewhere else where it's probably more realistic to occur.
Yeah, it's great. So this has been very enlightening. I love the back and forth, the practical approach to what could be a very sticky issue. Jeff, let me punt it over to you. Some last comments on indemnities or anything that, related to it that you think are important to mention.
Sure. I guess my overall comment on it would be to echo this at the start. For the business owner, this is most likely the biggest transaction you're ever going to undertake. And the indemnity is really the key provision where your $10 million deal could become an $8 million deal. So it bears all the sort of careful attention that your business does. And to John's point, it really helps to drill down in due diligence, helps to ask questions, helps to have a good advisor like you, Dominic, up front, quite honestly, because that can put them in a best position before the letter of intent is done. I think when a company comes together prepared at the letter of intent stage, that helps kind of grease the skids for the deal in general. And that's why I always try to get all the indemnity terms outlined in the letter of intent, so we're not fighting about it when we're drafting the definitive agreement. I think fronting everything and putting it on the table and getting it solidified upfront is the best thing a seller can do.
Boy, I'm so glad that you brought that up, Jeff. I couldn't agree more. We always advocate to our clients in working with their attorneys that we get everything on the table possible, right? You can't get everything but as much as you can, because it just makes for a smoother transaction later on, and you're not fighting when the parties should really be working together towards thinking about integration and transition, right? Not a time to be fighting. And the more you do up front, I think the better. Great advice. John, how about you? Anything that
Well,
you
I'm really frustrated as a buyer counsel when I've got Jeff doing that to me, because at the LOI stage, that's still the courtship. If there's potential other bidders out there, I'm trying to play somewhat nice, and the indemnity is probably the most important provision in the purchase agreement. And here I am, sort of getting backed into a corner when we're still trying to get them to let us in the door. Additionally, I may not be far enough along in my due diligence to be comfortable with my indemnity, and it's really pushing me into doing, sort of what's market generally for deals of this size in this industry. So, good for a seller's counsel when they do that. I definitely agree. When I'm representing a seller, that's so important to do. I think one point that's coming out now that's maybe a little unique is in this post-COVID world. How do you disclose against and how do you exclude or protect yourself for issues that are attributable to what's happening in the economy, or the ability of a company to continue with shelter-in-place orders or other restrictions? And one thing that we're really trying to focus on is having very narrow, specific disclosures, rather than saying, our supply lines have been impacted by, COVID generally. So trying to limit those disclosures, but still, recognize that this company, for better or worse, is not the same company that it was 5 months ago.
Jeff, it sounded like John was ready to do some battle there. I should have stepped aside and let that happen. But John, I think you bring up a really good point on the other side, and I think I don't want to overstep here, but I think what you said, if there hasn't been enough due diligence done, it's hard to lock into indemnity. So is that a pretty solid pre-qualifier? Not maybe 100%, but
No, that's absolutely fair, and it's tough to jump up a cap or something because the diligence shows that the company's been sloppy. What it oftentimes pushes us towards as a buyer is a specific indemnity where we're carving out a series of potential claims that wind up then being completely uncapped rather than subject to a slightly higher cap.
yeah, makes perfect sense. Jeff and John, this has been a great conversation, and I really enjoyed listening to both of you and getting both perspectives. And I know the M&A Unplugged community is going to get a ton out of this, hoping buyers and sellers that are listening really can get an appreciation for the other side. It's so important to understand that. Not that you have to bend, but you have to understand that, these issues from both sides. In closing here, Jeff and John, I'd love for you to leave your contact information with the M&A Unplugged community. How can they get in touch with you if they wanted to reach out? Jeff, why don't you start us off?
Sure. The best way to reach us is through our Chicago office number, which is 312-583-7488. And the name is Jeff Petersen. Thanks very much, Domenic.
Absolutely. John?
Thank you. And my direct dial is 312-324-8475, or feel free to email me at jschreiner@perkinscoie.com, perkinscoie.com. Thank you.
So I want to thank Jeff and John for taking time today to share some really important information about indemnities. We were going to try to get to a couple of other issues. I think what we'll do is maybe invite Jeff and John back to cover some other important topics to get the sell side and the buy side perspective. As usual, all of today's information will be available in the show notes. If you would like to learn more about the process of acquiring or selling a business, please visit our website at sunacquisitions.com, or feel free to reach out to me at drinaldi@sunacquisitions.com. I look forward to seeing you again on the next episode of the M&A Unplugged podcast. And until then, please remember that scaling, acquiring, or selling a business takes time, preparation, and the proper knowledge.
Thank you for joining us today on M&A Unplugged. If you enjoyed the show, please subscribe, rate, and recommend it wherever you get your podcasts. If you want more great information on how to scale, acquire, or sell a business, please visit our website at sunacquisitions.com.